Mr. Erwin to confirm that he will still tell us the truth?
I do, sir.
Thank you. Mr. Skinner?
Thank you, Mr. Chair. We had adjourned yesterday at the stage where my learned friend representing Mrs. Feinstein, Holden from Furen was about to cross-examine. There were two aspects that had arisen, one in relation to the affordability report and the second in relation to the contracts. I have been advised that the affordability report has been declassified, and accordingly that difficulty should now fall away. The position regarding the contracts is, however, somewhat more complex, and if I may just take marked as classified secret or top secret. Most of them, however, do contain a separate document which says, for example, it is hereby recorded that despite lack of classification marking on each page of the document is in fact classified confidential in accordance with security regulations of the Department of Defense and Armscor and must be handled accordingly. The umbrella agreements for each of the parties also contains a provision which in essence is the same in the various agreements, but says subject to the provisions in relation to confidentiality and or secrecy in the supply terms. Now, the supply terms is not what is envisaged will be put up at this stage. What we were wishing to place before the Commission were the umbrella agreements and the NIP agreements, which is an annexure to the umbrella agreement. But the provision then says subject to those provisions in the supply terms, any information obtained by any party shall be treated as confidential by the parties and shall not be divulged or permitted to be divulged to any person not being a party to the agreement without the prior written consent of the other parties, save that, and the relevant provision seems to be that there's a clause which says the South African government shall not be precluded from disclosing any information it deems to be in the public interest, save that it shall not be entitled to disclose proprietary information or information of a commercial nature and which is confidential without the written agreement of the seller. Mr. Chairman and Commissioner Musi, the terms of reference of this Commission as published do contain a provision which says documents which by law are protected from public disclosure will remain so protected. Now, there is a definition in the umbrella agreement of the parties, which in the example I was looking at stipulated that it would be Armscor, the seller, and the South African government acting through its relevant governmental department or ministry as applicable. It seems to me that this is a different situation from where two individuals agree that the contract between them shall be confidential. That can clearly be overridden by a court of law or in this instance by the Commission. The circumstances here are somewhat different where the South African government is a party and where there is a provision which says that it shall be confidential, but the government shall not be precluded from disclosing any information it deems to be in the public interest. My submission is that that seems to indicate that the decision as to whether the contents of these umbrella agreements and NIP agreements, NIP terms, can be disclosed rests with the government, not with the Commission. I am informed that numerous efforts have been made to get this resolved, but that the approach of the various persons seems to be that all the obligors must be informed and all of them must consent. That has been the sticking point, that certain obligors have consented, others have simply not responded, and that in the absence of the consent of all the obligors, the governmental authorities seem to be reluctant to say that they will, under the provision I referred the Commission to, grant leave for the information to be disclosed. So, in a nutshell, the position then is that the contracts seem to be confidential. and it would require governmental authority for the provisions to be disclosed. I raise that because, as I understand it, my learned friend wishes to cross-examine inter alia on the contracts, and clearly she has a difficulty because at the moment the contracts have not been made available to her.
I think we do have an interest in these contracts.
Yes, morning, Chair, Commissioner Musi. Armscor's position is as follows. We obviously consider ourselves bound by the confidentiality that is to be found in the agreement. Armscor was a signatory to the various umbrella agreements with other interested parties, government departments. Armscor has engaged insofar as the GFC contract umbrella agreement is concerned, which relates to the frigates. Armscor has been engaging with members of the German frigate consortium to get their consent to waive the confidentiality provisions that pertain to the agreement. That process is still ongoing. Unfortunately, the constituent members of that body are no longer in one homogeneous position because they have since left the consortium. But those senior members that we are aware of, we have been in contact with. Armscor per se has no objection to the production of these documents, subject to the counterparties, the obligors, agreeing to waive the confidentiality provisions. It does strike us, though, that these umbrella agreements really reside under the custody of the government and cabinet, who were parties to the agreement, and in fact the government was a signatory to the agreement. There seems to be some suggestion that Armscor was the custodian of these agreements, and whilst we obviously retain copies of these agreements, we don't see ourselves as really being the custodian of the agreements for the purposes of making a decision as to whether they should be disclosed or not. But we are willing to participate in any that allows these agreements to be placed before the Commission. We are not being obstructive in that regard. We are just fulfilling our contractual obligations to the counterparties and the obligors that were the contracting parties with whom we contracted. So to sum up, we have no personal objection from Armscor's point of view to the production, but we don't believe it falls within our province to produce the documents. It should also be pointed out that the particular industrial participation clauses which form part of an appendix or annexure to the agreements is not something that is within Armscor's particular personal knowledge. That related to DTI, and I believe that the department was indeed a signatory to the umbrella agreements in order for it to have certain rights, and obviously it had the corresponding obligations in terms of those agreements within agreements that pertain to the industrial participation, the NIP. So we don't believe it really falls within Armscor's purview to declassify or to allow that part of the agreement to be produced, because it's not something that directly affects Armscor. As I've said to you, we are, insofar as it does directly affect our witness, Mr. Norkier, who is going to give evidence about the frigates and the combat suite. We have been trying to get particularly that GFC contract umbrella agreement, using the term loosely declassified. I don't know if that clarifies anything to you, Chair, Commissioner Musi.
Thank you. Advocate Moran, do you want to add anything to what has been said up to now?
Chair, it's obvious that our interest really is with the witness that is presently before the Commission, who is a former minister of the Department of Trade and Industry and later Department of Public Enterprise, is no longer in government since 2008. And he has come to assist the Commission to give evidence with regard to the terms of reference insofar as they relate to the period when he was a member of government, and he has been doing that to the best of his ability. I believe the affordability report, which was one of the reasons why learned colleague couldn't proceed with a cross-examination yesterday, is or has been declassified, so that is no problem. I think questions can be directed at Mr. Erwin with regard to that affordability report, and he is prepared to answer questions to the best of his ability. With regard to the contracts themselves, really, I do not see how that has a bearing on Mr. Erwin's cross-examination. I'm not aware that there are any disputes with regard to his evidence and the evidence of the DTI. And I believe the methodology of the Commission has been to deal with various aspects. And at this stage, the Commission has been dealing with the DTI and its witnesses. And Mr. Erwin is the last of those witnesses. And subject to what my learned friend will say, I think the evidence should proceed. He should be cross-examined if my learned colleagues have any cross-examination to direct at Mr. Erwin. Thank you.
Maybe before I go to DTI, the evidence of Mr. Erwin and the statement that he has given us, does it have any reference to the contracts? Or does his evidence make any reference to the contracts?
Chair, no, it doesn't. It doesn't deal with the content of the contracts.
It doesn't deal with the contents of the contracts. Thank you.
No, Chair.
Mr. Chowe.
Thank you, Mr. Chairperson. Commissioner Musi, our instructions in as far as the contracts are concerned is that the DTI doesn't have particular problems in releasing the documents, other than, as the contract and Mr. Skinner have said, that all parties need to give their consent before those documents can be released. So without the consent of other parties to the agreement, we as the DTI, we cannot on our own agree that those contracts be released. And one other issue, Mr. Chairperson, which I want just to touch on is that through the Commission, it has been made clear that there seems to be no dispute in what the contract might say, especially, for instance, if it's the issue of the crediting methodology is in dispute. It's actually not in dispute. All the parties have common agreement what those issues are, and if one maybe has to know whether what those contracts say, what are the deliverables, is very clear on the contract and there is not dispute. So I would reiterate what the Commission have said, that there seems to be no issue in dispute in those facts which were raised by the DTI's witnesses, and we would like to stand by what the Commission has advised, and that will be our submission, Mr. Chairperson.
Okay, before, I'm sure you have heard what your colleagues have been saying. And I'm much more interested in trying to understand why do you think the contracts are necessary for the purpose of cross-examination of Mr. Erwin.
Chairperson, Commissioner Husi, the interesting comment made by my colleague previously that there are certain terms of the agreement that's not in dispute. It's interesting because we have not seen any of those terms of the specific agreement. It's precisely because we want to see the terms that we're asking for the contracts. We are submitting that the contracts are not only relevant for the purposes of this particular witness, but for many other witnesses still to come. It's very difficult to imagine the Commission complying with the terms of the Commission without actually having regard to the contracts that is the middle point of this investigation in some sense. And just to take this Commission to the relevant parts of this particular witness's evidence that makes the terms of the contracts relevant, one would first have to look at the criticism leveled at the contracts and the methodology followed after the contracts were entered into by our clients, which is not now before this Commission, but also at what is said by the witness himself. And I want to take the Commission to the witness's statement, and more particularly paragraph 23 thereof, where he specifically makes the following statements. It is apposite, however, to include in the material made available to the Commissioner a fuller briefing on the NIP and its implementation. Now, a fuller briefing on the NIP and its implementation clearly must imply the NIP terms of agreement that we're asking for. Related to this are the following pertinent issues that have been raised in the inquiry: the origins of the NIP, the allocation of credits, the amendments made to the criteria applied, the use of multipliers and the credit methodology applied, and then, very importantly, the variations made to the terms and conditions of the contracts. Those are the issues that we want to test in cross-examination against the evidence of this witness, because he doesn't only refer to these elements as being very important, he then discusses them and he comes to the following conclusion, and he wants this Commission to accept this conclusion, which at this point in time is still untested, and he makes the following point. Eventually, after he has discussed the various issues, he comes to the paragraph 43, where he says, I close this part of the submission of the members of the committee by emphasizing that the primary policy decisions relating to the STPP were taken at cabinet level. Thereafter, the committee used its discretion to give effect to Cabinet's policy choices. In using our executive discretion to give effect to those policy choices, some variations to the terms and conditions agreed to in the contracts were made, as attested to in the use of multipliers. That is exactly the use of that discretion that we want to test. We cannot test that without the content of the contracts. He goes on to say that the power to make decisions based on government policy is mandated by the Constitution, and then he wants this Commission to accept the following. I'm advised that in law, when a power to take certain decisions is accorded to structure of government, that power may be exercised as and when required within the framework of the law. Now, for reading for framework of the law, also within the framework of the contracts. And it's on that basis that we say that for this witness and many other witnesses to come, we need the contents at least of the umbrella agreements and the NIP agreements. My instructions are that, and I submit in any event that this Commission will agree with me, and I'm sure the witness will also agree, that one would not want to proceed with a piecemeal process of cross-examination. So that we obviously don't have a problem if the witness is excused, and as and when we get the relevant documents made available to us, and obviously depending on what those documents say, we can then approach this Commission and request that the witness be recalled, at which time the relevance of the request can be debated in this commission.
Thanks a lot. I can tell you, I don't really agree with you that the Commission will agree with you that it's undesirable that the cross-examination must be in bits and pieces. I don't agree with that. The witness is here. The witness has testified. You do have the affordability study report. In any event, that report has been in your client's possession for some time now. The only outstanding document is the contracts. I think you can be in a position to start with your cross-examination right away on the basis of the evidence that the witness has given and the affordability report, which has been in your client's possession for some time. There's the first issue. The second issue, as far as the contracts are concerned, I think it will be very helpful if you can tell us which sections of the contract or which areas of the contract you think you might want to concentrate on, so that when we approach or when the Commission approaches the various parties involved in this in the contract, it might be easier for them to agree if at all we tell them which sections of the contracts you are interested in. But then for you just to say we're interested in the entire contract because the witness referred to one or two clauses in those contracts, I don't think it will be very, very helpful.
Yes, Chairperson, may I answer the last issue first? The interesting thing is that I'm not able to say which parts of the contract I'm interested in because I haven't seen the contract. I have no idea which parts I'm interested in, but I understand from my colleague that the sections that I've been referring to are contained in the umbrella agreement as well as the NIP part of the agreement. So those two parts are the parts that I'm interested in. So that's the first point. Otherwise, the possibility is always there that I am allowed to have a look at the umbrella contract and the NIP agreement and then stipulate which clauses we would like to use in cross-examination, which is obviously also a possibility. That's one part of the issue. The second part is I appreciate the Chair's position as far as cross-examination is concerned, but I'm going to decline to cross-examine the witness at this point because that is my instructions.
Thank you. If at all we are going to decline to cross-examine the witness at this stage, unfortunately we'll have to excuse the witness.
Yes.
And I suspect at a later stage, if you come back and try and make an application to cross-examine this witness, there will be various issues that we'll have to deal with. But then before we close on this issue, let me just talk to my colleague.
Let me maybe add something to this debate. The portions of the contract that this witness has referred to relate to the credit methodology, where it is said that it was agreed that only 3 criteria would be used to award credits, namely the investment, export sales, and local sales. Now, all the evidence we have heard is agreed that those are the terms of the contract. So it is common cause that that is a provision of the contract. And there's no dispute that the department has deviated from those terms in the sense that they then proceeded to apply multipliers when multipliers in terms of the contract were not supposed to be used. So really, there can't be any dispute about that part of the contract. It's common cause. I don't know whether advocates divorce want to say he disputes that these are not the terms of the contract relating to the credit methodology. And I can't see how you can disagree with that. It's agreed. Dr. Jordan, who was one of the people involved in the negotiations, testified that that was a decision of the INOT, and that decision was translated into the contract, that multipliers were not supposed to be used. Now, the Department of Trade and Industry, through their witnesses, say that they've deviated from that and applied multipliers. So the question really is the justification for deviating from those terms, from that term of the contract. And I think your cross-examination could focus on that, the justification for deviating from the terms of the contract. The terms of the contract itself is not in dispute.
Commissioner, may I answer that? It may be that one particular term of the contract is not in dispute, as pointed out by yourself, but the witness's statement says that variations made to the terms and conditions of the contracts are of importance. Now, without seeing what the terms and conditions of the contracts are, it is impossible for me to know which questions must be put to the witness. It's a question of first getting the information and then putting the questions. Without the information, I'm not in a position to cross-examine the witness about the terms and conditions of the contracts and the variations thereof. And that is also my instructions.
I'll rest my case, because as far as this witness is concerned, the only issue about the contract relates to the credit methodology. And that term of the contract is not in dispute. Thank you.
Thank you, Advocate Voss. So, even after my colleague has tried to persuade you to cross-examine, you still decline to cross-examine?
Yes, Mr. Chair.
Thank you. Advocate Meran, do you want to add anything? Because we have made an invitation to those who are interested to cross-examine their client, and they say they don't want to.
Chair, it will be recalled that my learned colleague's clients have been at this commission when the DTI witnesses gave evidence. And those witnesses were cross-examined on various issues. It is surprising that now, when the last witness, who has been out of government for 6 years, is about to leave the stand, there's this matter of the contracts being so vital, when that issue has been before the Commission all along. Chairperson, a learned colleague has made an election not to cross-examine this witness. And if there's an attempt to recall this witness to cross-examine on issues which he could have been cross-examined today, those efforts will be strenuously resisted.
You know, even testified about how the multipliers were applied. They gave us the fees, and they gave us reasons why they think they were entitled to use multipliers. And they gave us reasons why they thought that the new the credit methodology as stipulated in the DTI policy document should be applied, and not the ones which has been stipulated in the contracts. The representative of the Alliance for Human Rights was sitting right here. They knew about this evidence. On some of those issues, they did not even cross-examine the witnesses. I'm surprised that now that the terms of the contracts are now major issue when a witness who talks only about policy issues just testifies. The people who were in actual fact applying that methodology, who used that methodology in order to achieve certain results, which results they made available to us, were never cross-examined about the terms of the contract. I find it strange that at this last stage, when the last witness who talks only about policy, is supposed to be cross-examined, that the terms of the contract becomes important. In any event, we have given them an opportunity to cross-examine the witness. They have declined to cross-examine. We did not stop them from cross-examining. Before I release Mr. Erwin, Skinner, do you want to add anything?
Nothing further, thank you, Mr. Chairman.
Mr. Erwin, thanks a lot. You are excused. Nobody is interested to cross-examine you at this stage. No, but then just before you leave, unless if you're told, besides lawyers for human rights, there's somebody else who might want to cross-examine Mr. Erwin. Thank you, Mr. Erwin. Nobody wants to cross-examine you. You are excused.
Thank you very much, sir.
Thank you. Thank you. Advocate Skinner, that seems to be the end of the witness of DTI.
That is so, Mr. Chairman.
What is going to be the next step now?
Mr. Chairman, as I understand it, there will still be in the future some evidence that may relate to the DTI in the sense of Mr. Jahendra Naidu's evidence, but certainly there is no intention to call further witnesses at this stage in relating to DTI. Mr. Naidu will be testifying on a range of topics, but of some relevance to the issues that are presently before the Commission. So that at this stage we have nothing further to place before the Commission, and it would seem that the Commission should then proceed to carry on with its published program of other witnesses.
Thank you. Advocate Lubana.
Chairperson, Commissioner Musi, our team has been requested to be present this morning. I do not know whether I should start by firing the salvo. In as far as our presence is concerned, I should give over to my senior colleague, Richard Solomon. But we're able to apprise you of the following. If we've been invited to come and update the Commission about our preparations as far as Mr. Fritz Norke is concerned, we'd like to advise you that we are at crossroads, Mr. Chair. What does that mean? Are we ready to cross the road to start taking him through the testimony? Those questions could be answered by a number of inquiries, and those inquiries were confident that they would be positively addressed also by Mr. Solomon. For our part, Chairperson Commissioner Musi, we have received a draft discovery affidavit from Mr. Richard Young. It's not signed, and probably I should recapitulate and remind you that Mr. Richard Young intends cross-examining Mr. Fritz Norke in as far as the aspect of the combat suite, in as far as the frigates are concerned, has to be looked at. Now, that's the area where Mr. Richard Young would like to go. But there's been events and journeys in as far as that process is concerned. Mr. Richard Young has been advising our team, myself, Mr. Ngobese, the Armscor team, the Arms Procurement Commission, that he's got volumes and volumes of documents that ought to be used in as far as the cross-examination of Mr. Fritz Norke is concerned. Now, that process has twisted and turned, it has huffed and puffed, and be informed, Commissioner Musi and Chairperson, it has frustrated us. We are halted in our foot track this morning because we are not even certain as to where should we start our preparations with Mr. Fritz Norke. Now, let's tell you what occasions this. Since we learned that Mr. Richard Young intends cross-examining Mr. Fritz Norke, there's been documentation after documentation sought from our side, from the Arms Procurement Commission, and we've been advised that Mr. Richard Young intends using a large profound of some documentation that we do not know of, that we cannot locate. The origins thereof are questionable, subject to the following, that there's no one better informed to assist this commission to divulge and use those documentation other than him. It makes sense, Mr. Chairperson, Commissioner Musi, to note what he says in that regard. But it also multiplies problems on our side in as far as our preparations are concerned. In this context, we are told time and again that there are additional documents. When we are just about to start our preparations in sitting with Mr. Norke, we are told that be advised that there is additional documentation that Mr. Fritz Norke has to sort or that the Commission has to give to us. Now, what does it do to us? It informs us that either we start consultation with Mr. Fritz Norke, ignoring that which Mr. Richard Young is drawing our attention to, or we wait for Mr. Richard Young to be certain that there's a cut-off point of his request for documentation, of alerting us that there are additional documents that have to be drawn to attention before we lead the testimony of Fritz Norke, including more substantially, whether the documentation that we have is adequate for us to lead this testimony. Now, what does that mean, Chairperson, Commissioner Musi? Either our inadequacy is going to be exposed, or we try to be adequate. Now, we've made several propositions to avoid this drama, and let's advise you, it is dramatic. It is dramatic because we're not in control of the process. We, as far as we're concerned, we say it with our head held high that we are ready to lead the testimony of Mr. Fritz Norke. We were ready even before the adjournment, Mr. Chair. We've read a very profound statement that has been prepared in as far as Mr. Fritz Norke testimony is concerned. We look at the document that supplemented it. We requested additional documentation in line with our research and preparations outside those documentation. Lo and behold, we're overtaken and confronted with the fierce agency of demanding that additional documentation has to be looked at by Mr. Richard Young. Now, we are where we are because of this background that we give you. Where do we start preparing, Mr. Chairperson, Commissioner Musi? Are we starting to prepare with what we have, or we should wait for next week for Mr. Richard Young to advise us there's additional documentation that we have to look at? Now, it creates a problem for us. And the issue of the documentation is being used as a string. I beg your pardon, Mr. Chair. Now, there's a tug of war. It's used as a rope in a tug of war as to whether we as evidence leaders, are we ready to lead the evidence of Mr. Fritz Norke or not? Now, I've seen communication where Mr. Richard Young boldly assures whoever that he does not think that we are ready. Now, we cannot lose control of being evidence leaders and guiding this process. Chairperson, Commissioner Musi, we have several practical propositions that would allow us to cross the road. Now, we want to make the following suggestions. We intend sitting down with Mr. Richard Young on one condition, and we humbly make this request, if he is legally represented. Now, the reason why we make this proposition is because if he's legally represented, there'll be accountabilities, and there won't be accusations that we bulldozed him into practical propositions that we'd like to make to guide this process. Now, this includes the following. We will agree with his legal representative to say, from now on, these are the documentation that would use in as far as leading the testimony of Mr. Fritz Norke. Outside this cut-off date, and this is in line if we agree on choosing a cut-off date. One or the other, Chairperson, Commissioner Musi, we have to draw a line in sand. And that would be actuated by that cut-off date that we are envisaging. Now, once you agree on a cut-off date, then you will say to Mr. Richard Young's legal team that, in our view, we've seen the documents that Mr. Young intends using in cross-examining Mr. Norke, and be apprised that up to so far, Chairperson, Commissioner Musi, we have 1,065,000 voluminous documentation, some of which my colleague Mr. Ngobesa managed to sift for us. We've looked at them, And without conditioning you into total obedience and thinking like us, we assure you most of them are irrelevant. And I've got to be careful not to testify at this stage in the absence of Mr. Young. Now, going back to meeting with Mr. Young's legal team, we'll be able to give them assurance that we will follow and rely on the documentation that we feel in line with the principles of basic rules of evidence that are relevant, and that would assist in as far as the terms of reference that we deal with at this stage of the Commission, in as far as the testimony of Mr. Fritz Norke's concern are applicable. We'll say to that legal team that these are the documents that we believe are relevant, these are the documents that we do not believe are relevant. If they disagree with us, we'll isolate that point and come and argue before you, and we trust your discretion that would make a better informed decision. Now, what does that mean, Chairperson, Commissioner Musi? That would guide the process ahead. Then we won't be confronted with a fierce agency saying to us before we start leading Mr. Fritz Norke the next day to be told that there are additional documents that you should look at. Now, we have decided to reach out to Mr. Solomon's team. They agree with this approach, and I'm certain that they would put themselves on record in that regard. But in closing, Chairperson, we've been ready, we are still ready, and we assure you that we can start leading Mr. Fritz Norke testimony tomorrow on one condition. This Commission is not going to accept a large component of this 1,065, I beg your pardon, please help me compute, 1065, Mr. Chairperson. My act is not together. That's 1,065, that's 1,065 voluminous documentation. We haven't had sight of some of this documentation. Now, would we be prepared to consult with Mr. Fitznoke without seeing some of these documentations? No. What does that mean? The process of our preparation is being halted in our own foot tracks. Now, this journey has amazed us. It remains a journey, it's not an event. For us, we're of the view that preparing a witness is not a journey, it's an event. Requesting documentation is not a journey, it's an event. But Mr. Young makes it a journey. For instance, we do not know as to whether next week we are going to be told that there are additional documentation. Now, in closing, Chairperson, Commissioner Musi, please help us, assist us. Give a directive that would say, we meet with Mr. Young, Mr. Richard Solomon's team, and Mr. Young should be represented. And we agree on formulation of what could be guidelines to assist us to third ahead in as far as leading the testimony of Mr. Fritz Norke. And in closing, we say the following. If this one witness who is certain would be easy to lead, that witness would be Mr. Fritz Norke. Simple, uncomplicated, understands his story, simplifies concept, and we are surprised and perplexed that up to so far, we haven't led this witness. We've assured ourselves that it's not easy to bring testimony before any forum, particularly this commission. We have led very difficult witnesses, and we're relaxed when we're just about to confront the testimony of Mr. Fritz Norke when you're confronted with requests for documentation. So, Chair, Commissioner Musi, you direct us tomorrow and say we should start. We do not know whether we will be told that you are leaving some documentation out. And there will be consequences when you do that. Our reputation will be at stake. We may be reported to our profession. And one can imagine, we pose ourselves the following question. If it be found that it's true that we ignore some of this documentation that Mr. Young has drawn our attention to, and it is relevant, there will be consequences. Firstly, we'll be failing our duty to the profession that you both know, undoubtedly so. We'll be failing the duty to this commission, and significantly would be putting our careers at stake. Assist us, Chair.
Thank you. Advocate Solomon, I think last time when we were here, we did give some type of a direction or some type of directives on how this issue should be dealt with. If you recall, I ended up saying that there is no way in which we're going to be held ransom by a person who ends up asking documents after documents and making it very difficult for the evidence leaders to prepare the witness. And secondly, we said that Dr. Young will not be allowed to use documents in cross-examination which he has not included in his discovered affidavit. And I thought on the basis thereof, the evidence of Mr. Norkier will be much easier to prepare. You only take into account the documents that Dr. Young has produced, has mentioned in his discovered affidavit. Because mind you, for Mr. Norkier to come in and give evidence, it doesn't depend on what Dr. Young is going to say. He must prepare a statement, come and give evidence. If a cross-examination crops up, it can crop up. But then Dr. Young will only be allowed to use documents that he has included in his discovered affidavit. I thought that was the basis on which we parted ways the last time.
Yes, Chair, Commissioner Musi, that's my recollection. There was a ruling by yourself and Commissioner Musi to that effect. The difficulty that one is faced with is we have this draft discovery affidavit that my learned friend, Mr. Labala, has spoken about, which runs into over 1,000 documents, probably 10 or 20,000 pages of documents. One doesn't know what the length of each document is. That draft discovery affidavit was only produced on Friday, the 14th last week. We've looked at it. It's very difficult to assess documents just from a schedule. We don't have the documents. It seems to us there are probably a number of documents in that schedule that are irrelevant as far as Mr. Norkier is concerned, and we would object to any cross-examination concerning those documents. But we can't make that final determination until we've seen the documents. We've written to Advocate Mdumbi at the Secretariat to request him to request Dr. Young to produce the documents that he's foreshadowed in his draft discovery affidavit, Schedule Part 1 and Part 2. We must just place on record, Chair, Commissioner Musi, just some of the chronology, because it may be important when one has at some point in time to determine what is to be done with the ongoing request by Dr. Young concerning documents and his application to be allowed to cross-examine witnesses. Just to give you a bit of a chronology, on the 17th of October 2013, Dr. Young applied for leave to cross-examine Mr. Norkier. You may recall that his evidence-in-chief stood down to allow Dr. Young an opportunity to prepare for that cross-examination and obtain insight into documents. He provided a supporting statement on the 20th of October to which he attached a number of documents. On the 25th of October, Chair, yourself and Commissioner Musi granted leave to Dr. Young to cross-examine Mr. Norkier. All the documents submitted by Dr. Young were then provided at that point in time. What he then subsequently did is he withdrew that application and brought a second application on the 3rd of November 2013. And in that application, he specifically says that I withdraw my previous application. Attached to that application was an appendix in which he requested a list of documents, which, again, you'll recall, Mr. Norkier was charged with locating and providing, and he spent many, many weeks, you'll hear when he gives evidence, literally maybe 6 weeks, in what has become known as the icebox, where these documents are located, and which has no indexing and no proper collation of the documents. So he's really spent literally hours, days and days of his time to be of assistance to the Commission. He has other duties at Armscor, but he's been engaged in that exercise. What subsequently happened is there were further requests that only came to our attention much later. My attorney from Bowman Gilfillan, Ms. Kabini Zondo, wrote a letter to the Commission on the 27th of January, setting out that there'd now been further requests. Subsequent to the 3rd of November, there were 2 further requests by Dr. Young for documentation. It was in a letter of the 17th of December that we requested the Secretariat to use its powers to get Mr. Young to discover under oath. That was on the 17th of December. He only discovered on the 14th of February, as I mentioned, and that's not proper discovery. It's not confirmed under oath. But I think the upshot of it is you did make a ruling that he should not be allowed to refer to documents that are not in his discovery affidavit. Difficulties, he now has this very comprehensive draft discovery affidavit, which my learned friend Mr. Labala has referred you to, which places him in a position where he doesn't feel that he would do justice to the Commission to lead Mr. Nokia when one doesn't know what the state of the documentation is. From our perspective, we have spent many, many hours and weeks in obtaining the documentation, in making Mr. Nokia available, in preparing what we believe is a more than adequate statement, which will be amplified, and Mr. Nokia is ready to give his evidence and is anxious to do so. Because it weighs on him the fact that he has to give this evidence and that he's probably going to be detained in giving this evidence for a number of weeks if one looks at the sheer volume of documents. But I think what Mr. Labala is saying is sensible. The only way one can try and curtail this entire process is to have some formal structure where we can agree with Dr. Young's legal representatives what are the documents that are relevant, what are the documents that are going to be used. Otherwise, one's going to have a continuous interruption where the relevance of a document becomes an issue, the preparedness of the evidence leader, senior counsel Labala, whether he's prepared to take the witness through that document, which he hasn't yet seen. So it's all very unfortunate, but I think one should try and get some sense and some type of structure into the approach. And I think what Mr. Labala is suggesting is sensible. I don't know if it lies within the province of the Commission to make such a ruling. But anything that can just allow Mr. Nokia to give his evidence as quickly as possible and in the most efficient manner, we will support. Thank you, Chair and Commissioner Musi.
Advocate Bala, as I understand it, you are ready to lead the evidence of Mr. Nokia. And I would suggest that you go ahead and prepare on the basis that you have prepared so that you can lead Mr. Nokia on Monday. 2, I think we gave an order that, that Dr. Young will not use any documents in close examination unless those documents are contained in his discovery affidavit. As I understand you, we don't have a discovery affidavit now. because that's still a draft. 3, I think it must be made clear to Dr. Young that he is not going to be allowed to use any documents to cross-examine Mr. Nelke unless, 1, that document, he has mentioned that document in the discovery affidavit, which we ordered him some time ago to provide us with. 2, that he has made a copy of that document available to you so that you can be in a position to deal with that document with a witness. Otherwise, if at all, I'm afraid we might not be in a position to say to Dr. Young that he must obtain the services of a legal representative. But then I agree with you, if at all it is possible that he can get to the service of legal representative, maybe that might help in order to bring some structure in the possible cross-examination of Mr. Nelke. But as a starting point, I want you to be ready with Mr. Nelke on Monday morning. Other arrangements can follow later on.
Chairperson, Commissioner Musi, tedious as it is, we'll do our best, but may the following be put on record. We do not intend shortchanging this commission. That might come out with consequences that might be dire to us, in line with our duty to this commission and our profession. As we led at this draft discovery affidavit, we discovered that there are highly relevant documentation that we have never had sight of that would like to take Mr. Fritz Norgate through in presenting his evidence before this commission. We invite you to worship with us on this consensus altar, Chairperson, Commissioner Musi. We'll determine that after consulting with Mr. Fritz Norgate, those consultations could start sooner than yesterday, meaning today or tomorrow. We'll be better informed as to whether are we prepared to take him through all the relevant documentation that has come through our attention after glaring at this informative draft discovery affidavit. Now we have to be careful, Chairperson, Commissioner Musi, not to cut too close to the bone. We cannot track a duty beyond us and would be shortchanging more significantly this commission if we confidently believe that we could discharge this function of leading the testimony of Fritz Norgate on Monday if there is detail and information that we still have to sort. And we want to put the following on record, and I'm certain that I'm going to put Mr. Solomon on the spotlight. He's even closer to the lights. I'm going to make it a point that he assists me in confirming the following. We have discovered on the documentation that we've gone through that they are very highly classified details, and we're going to invite to go into camera. And this time, we are going to go into camera. I will demonstrate to you. Now, there are also consequences that we need to take into confidence about. We may end up having a commission within a commission if we go on the way you are directing us. And one or the other, we could be wrong, Chairperson. Let's, Commissioner Musi, we say this cautiously. We think, that's our view, that's this team's view. We think that Mr. Young wants to have a commission within a commission and will resist it. Now, assist us to resist that by sitting with his legal team. And I believe it's our view that you could direct that he should be represented when we meet with him, avoiding the consequences of saying we bulldoze him into making certain concessions. Now, if we sit with his legal team, we'll be able to advise them about the following. These are documents we think are relevant. These are documents that are not relevant. If you want to debate the relevance, let's go before the commission. We'll make it a point in limine. That could only happen, Chairperson, if we have led some of this documentation. For instance, I wish we had a copy of this draft discovery affidavit. We have seen that some documents are not relevant. They relate to a litigation that Mr. Young had with Armscor and the DOD. Now, if you invite and accept this documentation, you'll be having a commission within a commission. We're not going to allow it unless, when you exercise your fairness instincts, that we do not doubt, you insist that this testimony should come in. We could take you through this draft affidavit, advisedly, so to demonstrate to you that...
Advocate Luala, unfortunately, it's not a discovered affidavit. That, as you said, it's a draft, it has not been signed.
May I interpose, Chair? Thank you, Chair. But there is some relevant documentation that we'd like to look at. My colleague Ngowes has even been drawing my attention. I've seen some of the documentation that are not before the Commission. Now, what does that mean, Chair? It means we've got to delve deeper, look at the content and the context of this documentation. My colleague has captured it so well. At face value, we can see those that are relevant, those that are not relevant. Actually, there are even some that we're looking at that
Advocate Luala, Commissioner Moses has just told me that I must tell you that Monday call Mr. Norkie. We proceed with Mr. Norkie. If at all there are difficulties, we'll deal with them as and when we go along. Secondly, if at all we discover that there are certain documents that you need to deal them with Mr. Norkie, I'm sure we can do that in the evening because we mainly are going to sit only between 10 and 4. After 4, then we can deal with those documents.
Chair,
Otherwise, if at all we're going to sit here and try and identify what are the likely difficulties, we will not start. And I want to proceed with Mr. Norkie on Monday the 24th, as we arranged.
Chair, we will proceed on Monday. We wanted to identify these difficulties with a view to identify solutions.
Okay. 2, if Dr. Young wants to cross-examine, he'll make an application. He'll tell us exactly on which issues does he want to cross-examine, which documents he wants to deal with. We'll make a ruling at that stage.
May I pose a question, Chair? We've confirmed that we'll proceed on Monday. I'm forced to give you an if question. I know that the future of this commission doesn't lie on if. I've said it several times. What if this documentation in this affidavit that we looked at before we proceeded here, that is highly relevant, that we do not have, that we are seeking that he has? And fortunately for us, Chairperson, Commissioner Musi, be informed that we've consulted with Dr. Young, we've been to his offices, we've seen volumes of documents that he have in a storage, and we know that some of this documentation the Commission doesn't have, our colleagues from Armscor do not have, the DOD does not have, and we are looking for that documentation. Hence we say, Chairperson, Commissioner Musi, and please join us at this consensus altar. We want you to worship with us there and agree with this proposition. We'll be better informed during the next coming days, and if there are difficulties, we'll let you know, but we'll do our best to be prepared to proceed on Monday, Chairperson. Commissioner Musi, thank you.
Thank you. Then we'll proceed on Monday morning. If at all at the later stages a need to adjourn and give you a chance to go through some of the documentation that Dr. Young would have made available to you, we'll do that at that stage. But then we start on Monday with Mr. Norkie.
Thank you, Chair.
Advocate Solomon, Monday morning.
Thank you, Chair.
Thank you. We'll adjourn.